So criminal trials are not only a search for guilt, but a test to whether justice has been pursued through lawful means. In this case, the accused person is charged with false publication, the particulars being that on the 13th day of November 2024, at an unknown place within the Republic of Kenya, he intentionally published fake data, being a funeral procession with a casket covered with a Kenyan flag, escorted by a military officer in a ceremonial uniform, which he captioned, and I quote, President William Ruto's body leaves Lee Funeral Home over computer system X using an X account, landlord at Gabi, with intent that the data shall be considered as authentic. The accused person denied the offense, and in its endeavor to prove the charges, the prosecution called 6 witnesses. In defense, the accused gave a sworn statement and did not call any witness. So you'll allow me not to go through the summary of the evidence, which was quite lengthy. I want to go straight to the issues for determination. Just a minute. So the court has considered the evidence which was adduced by the prosecution and the defense. I've also considered the closing submissions by the defense and the Law Society of Kenya. In my considered view, the issues for determination were: 1, whether the prosecution proved the impunged publication originated from or was controlled by the accused person, and 2, whether the electronic evidence relied upon was lawfully obtained and admissible. So on the first issue, under Section 22(1) of the Computer Misuse and Cybercrimes Act number 5 of 2018, it provides that a person who intentionally publishes false, misleading, or fictitious data or misinforms with the intent that the data shall be considered or acted upon as authentic with or without financial gain commits an offense. From the above provision, Section 22(1) criminalizes the intentional publication of false information through a computer system where the publisher knows the information to be false and where the publication is calculated to cause panic, chaos, or damage of reputation. In this case, while the screenshots of the impunged posts were produced, screenshots alone merely demonstrate that a publication existed. They do not establish authorship. The central question before the court is whether the accused person was positively linked as the person who published this alleged post. In this case, there was no forensic digital evidence which was produced linking the accused person to the creation and sole control or operation of the X account. Further, no data was obtained from the service provider identifying the subscriber, IP address, device, or login history associated with the accused person. The IO told the court that the X account had the accused person's personal information. In his defense, the accused conceded that his personal details were in the account since he had been tasked to manage the account. The accused, however, clarified that 3 other people had access to the account. While the accused may not have named the other individuals who had access to the account, it's straight law that in a criminal trial, the burden of proof never shifts to an accused person. It remains with the prosecution throughout the trial. The onus, therefore, was upon the prosecution to prove it was indeed the accused person who had posted the impunged post. The court has carefully scrutinized the cybercrime and digital forensic report, which was produced in court as Plaintiff Exhibit 2, and in particular on page number 6 of the said report, which has the details of the impunged post subject to these proceedings. The said page clearly shows the post was done on the 13th of November 2024 at 11:15:27, the timestamp being at Nairobi. I do believe this is a very relevant fact, since from the evidence, the accused person herein resides in Eldoret. Indeed, that is where he was arrested. There was no evidence before the court that on the material day, the accused person was in Nairobi. This begs the question, if indeed the accused person was in Eldoret, how then did he post in Nairobi? Further, from the cybercrime investigation report from the Communication Authority of Kenya, that is CAK, which was produced as Plaintiff Exhibit number 8, it clearly indicated the phone number linked to the X account, that is landlord, at Gabi was 0790027 817. However, from the evidence, this number was not linked to the accused person. According to the witness from Safaricom, who was PW5, the accused person's phone number was 0799357515. Indeed, even in his defense, the accused person conceded to this fact. There was, however, no report produced in respect to the phone number 0790027817, which was linked to the X account in question. I believe this was either a very big oversight on the part of the investigators or a deliberate effort to eliminate culpability on anyone else, leaving the accused person to shoulder the blame alone. Courts have consistently held that electronic evidence must be supported by technical or forensic linkage connecting an accused person to the device or account used. In this case, even assuming the publication was false, the prosecution failed to prove the most critical element of the offense, which is that the accused person made, control, or caused the publication. The court therefore finds that the screenshots without origin verification carried limited probative value regarding the identity of the account. Further, it was the onus upon the prosecution to establish what this court will term as a digital nexus between the accused person and the offending publication. I dare say no such nexus was demonstrated because the prosecution failed to establish two vital ingredients. Number one, the IP address correlation placing the accused person at the time of the publication, and two, evidence excluding access of the account by any other third parties. In his defense, the accused conceded that he had managed the account landlord at Bogzabi, which was used for marketing purposes. The accused, however, confirmed 3 other people had access to the said account. Digital evidence requires strict proof of integrity and authorship. Mere association with an account is insufficient to sustain criminal liability where reasonable doubt exists. The court takes judicial notice that cybercrime prosecutions must be approached cautiously because online identities may be fabricated and accounts may be shared, hacked, or impersonated. In this case, there was no evidence which was obtained from the social media platform Xcorp regarding the account registration details, linked email or telephone numbers, IP, login history, and device identifiers. While the court accepts that an offensive or false material may have been published online, criminal liability under Section 22 only attaches to the actual publisher. In this case, the prosecution failed to bridge the evidentiary gap between the existence of the publication and the responsibility of the accused person. On the second issue, even if the court was to accept the prosecution evidence against the accused person from the evidence of the accused and the submissions by the defense and the Law Society of Kenya, the accused person's gadgets were seized and examined forensically without any court order. Indeed, the investigating officer in his evidence considered to the same. Even the witness from Safaricom, who was PW5, considered he had extracted the accused person's personal data and shared with the DCI officers without any formal court order. On cross-examination, the IO tried to sanitize the process by claiming that he had later gone to court and filed a miscellaneous application on the 16th of November 2024 and obtained orders on the 18th of November 2024. It should, however, be noted that the said miscellaneous application and orders were never produced in court. Be as it may, even if the court was to indeed assume that the IO had gotten orders on the 18th of November 2024, this was way after the illegal search and seizure of the accused person's electronic gadgets. Under Article 31 of the Constitution, it guarantees every person the right to privacy, including the right not to have their person, home, or property searched or their possessions seized except in accordance with the law. Under Article 50, subsection 4 of the Constitution, it provides that evidence obtained in any manner that violates any right or fundamental freedom shall be excluded if the admission of that evidence will render the trial unfair or otherwise be detrimental to the administration of justice. In the case of Ismail Mona Otieno versus Republic, the court observed that evidence obtained in a manner that violates any right or fundamental freedom in the Bill of Rights shall be excluded if the admission of that evidence will render the trial unfair or will otherwise be detrimental to the administration of justice. Similarly, in the case of Okia Omutata versus Communication Authority of Kenya and 8 others, the High Court emphasized on the intrusion into digital data and stated that it must be strictly comply with the constitutional safeguards. Further, under Section 118 of the Criminal Procedure Code, it requires investigators to obtain a search warrant before searching the premises or seizing property unless under exceptional circumstances. Electronic devices such as mobile phones and computers contain extensive personal data and attract heightened constitutional protection. In this case, not only were the accused person's gadgets seized unlawfully, they were subjected to forensic examination without any judicial authorization. I do believe the forensic extraction constitutes a separate and more intrusive breach. In the case of Republic versus Mohammed Bashir Mohammed and another, the court held that digital forensic analysis requires judicial authorization because it exposes private communication and personal data. In this case, the investigators disregarded the constitutional safeguards since the post in question involved the President of the Republic of Kenya. However, under Article 27 of the Constitution, it guarantees equal protection of the law, while Article 244 obligates the National Police Service to comply with constitutional safeguards and respect human rights. The fact that a publication mentions or concerns the President does not suspend the constitutional safeguards or justify investigative shortcuts. The criminal process must never become a tool of expediency merely because the subject of the alleged offense is high-ranking or politically sensitive. Constitutional safeguards exist precisely for such moments. The court finds the investigators bypassed the legal safeguards due to the perceived gravity of the post involving the President. Admission of such evidence would legitimize the unconstitutional investigation methods. Constitutional rights are tested more severely in moments of public pressure, and it's precise at such moments that courts must insist on strict adherence of due process. Having excluded the unlawfully obtained evidence and finding no independent proof linking the accused person to the impunged publication, this court finds that the prosecution has failed to discharge the burden of proof beyond any reasonable doubt. Accordingly, the accused person is hereby acquitted under Section 215 of the CPC.
Yana, thank you for the much reasoned ruling that the court has rendered. I wish to thank the Law Society of Kenya and the defense team of the lawyers that are present before this court. That is Stanley Kinyanjui, Atina Swiga, myself, and Shadrach Wambui, who was the background. We also wish to thank the state, the DPP, for prosecuting a matter that was brought that had no legs to them. But they have done a good job. And we want to thank the court, that the court has stood with the constitutional safeguards. And the court has stood, has looked at this young man and given him a lease of life. The young man can proceed with his studies, and the young man can trust that there is the judiciary that is independent, that decides cases without fear of failure. This is a landmark decision, as we had said. It was the only matter out of the demonstrations that has gone to judgment. All the others were withdrawn, and we thank the court that the court has rendered a reasoned judgment. It is only unfortunate that it is not a court of high status, because this serves as a roadmap for the DCI and the investigative officers to follow the procedures when a matter cybercrime is mentioned. We are not condoning the offense of people misusing their phones, but the state has a duty to follow the statutory and constitutional roadmaps that have been presented before, or else the state might never convict anybody, those especially who have committed serious offenses. Your Honor, that's all. I am the only lady seated here. She's telling me that her voice can tone me down. Allow her to say one word.
Yes, Ms. Martina.
Yes, Your Honor. We want to take this opportunity to thank the court for the reasonable judgment. And we want this to serve as an example for those who have been mandated with law enforcement and discharging their mandates, that they should follow what has been prescribed in the Constitution without fear or favor of any person, and that the ordinary mwananchi, the ordinary Kenyans, will not be subjected to unfair treatment in the criminal justice system, and that the criminal justice system will not be used as a ploy to show who is stronger than the other. Your Honor, we are grateful for your judgment. Thanks.
Yes, Mr. Kinyanjui.
Your Honor, mine is just to request that the cash bill which was deposited, a cash bill of 50,000 shillings, be returned to the depositor.
Very well, so we can have the cash bill released back to the depositor. And thank you very much, councils, for the sentiments.
Much.
Much obliged.
Thank you.